And then we may consider whether we need to hear you on the JS2 issue.
My lord, yes. It doesn't knock me off my stride too far. But I have to read my handwriting, as opposed to the typed. Can I go first with the first of the jury questions that remain? And go first of all to E4, which is in bundle 5A, if anyone's working from a hard copy. And I would just like to show you what happened, because there is more to it than you were shown by my learned friend. The incident begins at 4072, 6th of February 2014, so it's about a month before the end of the trial. You'll see at the top of the page, court resumes at 2:25 p.m, but they're all in chambers with the judges, with the attorneys.
Yep.
And Marlene Catwell is the juror. And the first part I would like to take you to is at 4073. She says she said, perhaps I should just say, line 24, the witness, that's Catwell, one Friday. So he doesn't identify which Friday. When we weren't at court, I went to visit him, my son. We were supposed to go into the lobby, but him never come out in time. Just as him come out to me, Andrew St. John's came in that way. He saw me, he was a bit panicked, and I look at his face, and he was a bit panicked. It's not quite clear who he is, but perhaps he's talking about her son. And then she continues over the page.
Her son or St. John?
No, her own son.
But she says her own son didn't come out.
Okay. Oh, he saw me, sorry. In other words, St. John saw me.
Yes,
he was
I think so.
I look at his face. Forgive me, my lady, yes. And then she goes on to say, shortly afterwards, when he came out, when he came out of the vehicle, my son came in and him said to me, "Sir, inaudible." I was a bit angry with my son. I was a bit angry because he knew that I was coming and I didn't want to meet up with them, so I think his delay means that St. John's would have seen me. So I was angry at him. I think I must be her son now. You know me and I come back because him see me. I never related anything. But she then goes on to talk about her conversation with her son. Near the end of the page, me tell him me and a boy in the jail fight. Me go at the medical centre and him said to me. So there's seems to have been some sort of fight. And then over the page, 4074, she says, no, KARTEL saw him and say him see him mother a juror, and say St. John's tell him, but him not tell the other rest of the man. So she seems to have seen, or rather, KARTEL appears to have been involved as well at some point. It's not always easy to understand quite what is going on. But then if one can drop down to the end of the page...
I think we can probably take it the judge understood what was going on.
The judge, I'm not sure he necessarily did. But towards the end of the page, 4074, they who? She says, the prisoners at the bar are there, and my son is there, and they know that I am a juror. If anything should go down, probably, I don't know, if anything go down, I would hate to know that me is the one who have to bury you. And he said, KARTEL said to him, he was saying if. So her concern is being on the jury, and then if the jury convicts these defendants, then she's going to be in trouble. Or her son might be in trouble, rather. Yeah. It's not that she personally is going to be attacked, but she's concerned about staying on the jury, because if she does and the jury convicts, then there might be trouble for her son. That's her concern. Then you see Mr. Finson, that's Mr. Palmer's counsel. She don't even have to say any more. Juror KARTEL said to him, if he. And then the judge says, okay, what I want to know, though, how you feel. You can bother with this, you can bother with the burden and all of this burial thing you talk about. The witness, Your Honour, the only thing I am concerned about is my son's safety. They are there, he is there, they know him. Andre St. John's is on the said block. All right, that's a lot. Please just step down for us, please. It's too much for her. Having heard what she said, I have changed my opinion. Yes, it's too much. So obviously at first he was thinking, this is storm in a teacup, but now he's thinking rather differently. And then the prosecutor, Mr. Taylor, does seem that concerns with her son, and if the authority can find a way to move her son from Horizon, my lord, so she could have peace of mind to continue on the jury, the judge says no, her son is now in the custody of the state. And then, yes, all right, the view is, Mr. Taylor, as prosecuting counsel, I wasn't trying to be brief and brush your comment aside, but from the performance that I saw her, it's clear to me for a parent to be placed in that situation that the body that she's sitting on may make a decision that may affect the safety of her son adversely. As a parent, it is an act that you don't want to place her in. In the circumstances, I don't think it's something she can properly deal with. You saw her performance just now. And then he goes on to say, therefore, I think I had better discharge her. And then towards 4077, towards the end of the page, Mr. Rogers, I think he's Mr. St. John's counsel, but I stand to be corrected. Another issue. For the record, I would hope that what has happened was not discussed in the jury room. And as a consequence of that, it might have been left with the rest of the jurors. I know it's a painful aspect at this point, but a real concern. May I inquire through the registrar as to any particular person in respect of the jury who would be seized of this information? Registrar, when the information came, sir, two persons spoke to me, that lady and the foreman, in fact, forewoman. I inquired if anybody else is aware of the situation, and she said, no, just the two of them. So that would presumably be the forewoman and the juror.
Yeah. If you're going to read on, I don't think we need to read aloud the foreman's name.
No. My lords, my lady, if you could just read on to the end of to 4080, to the end of 4080, you will see what the upshot was and what takes place. So, my lords, my lady, what you get out of this is no one else knows except the forewoman and Catwell. It's not gone to the jury. And my lords, my lady, there's no reason at all to doubt that, because even the forewoman, I think, says she only found out on this very day. And then the judge finishes at 4081 saying, I'll make an announcement that she has a personal difficulty, and I'll dismiss her. Now, in my submission, there's nothing wrong with any of this. This is a perfectly sensible way of dealing with the matter. The judge has assured himself that no one else knows that there has been some incident. And I might add, the only, quote, incident is that she is concerned that her son is in the same, appears to be in the same prison as these accused. That's her concern. There isn't any concern, certainly on the face of the record, that her son has actually been threatened by any of the accused already. So there's no basis for saying that she would have, so to speak, spoken to other members of the jury and said that, or indeed to the forewoman. So I submit there's nothing here which required the judge to go any further than he did. My learned, I think Can I just ask you also to note that this incident began, I think, going back at 2:25 p.m. That's 4072. That's when the Chambers meeting begins. When you get to 4082, you can see the time at which the Chambers meeting finishes at 2:50 p.m. and then the court resumes at 3:16 p.m. Now, I mention that because it is suggested that the appellants themselves should have been in Chambers at the time. Well, there are two answers to that. There was plenty of time for the appellants to be told, to the extent it was relevant, what had happened by their counsel. The gap between 2:50 p.m. and 3:16 p.m. The second point is, anyway, their counsel just simply didn't object to the course taken by the judge of holding this in private. Nor did they object to the course, the more general course the judge took of removing the juror. That's a point made by the Court of Appeal, and in my submission, that's a good point. And there's no reason to interfere with the Court of Appeal's judgment on this issue, which is referred to in our respective cases. Can I just also draw your attention now to the case of Bonnet, where a not entirely dissimilar thing appears to have happened, and it's in the electronic bundle at page 6287. And that's where the case is. Forgive me, my lords, I think I've picked up the wrong bundle. It's 6287. The relevant paragraph, if I can ask you to look at it, 6289, paragraph 21. And if I can just ask you to read that yourselves.
Just paragraph 21.
Sorry, paragraph 21 and paragraph 22. And then 23. It's 21 to 23. In particular, 22 to 23. Where a similar sort of argument was run in slightly similar circumstances. 23 in particular. And the reason I draw attention to that is there are two things. First of all, it's up to the judge. When you get these unusual spin balls that come your way, it's up to the judge in the immediate circumstances to work out what is the best way of dealing with it. And I do submit hindsight and perfection are rather dangerous guides when that's the question. And that's the Orgles case. The second thing is the Lord Hope emphasises, well, in that case, the appellant had 3 previous convictions, and the idea was that the juror, knowing the appellant, might then have gone and told all the other members of the jury, to which Lord Hope says, but there was simply no evidence of that. So we're not going to interfere on that ground. And I submit, well, it's not identical, but it's a similar type of situation. So I submit, for that reason too, there's no reason to interfere with the Court of Appeal's view of that jury incident. If I can go now to the third point, can I just mention this? The judge, just basic facts, the judge persistently gave jurors very strong warnings right at the beginning of the case, and we set them out in our with the main ones. Right at the beginning of the case, he emphasises to the jurors in terms that they are the judges, it's a phrase he keeps on using. You are the judges, and you must decide in accordance with your oath. And I think if I can just go to the key bundle of documents, and it's we set it out, the relevant bits in our written case. At page 6236. And we give the references, but you can see paragraph 66, and then I'm ashamed to say 65, follows after 66. Those are the things he says right at the beginning. And 67. Now, so very clear direction right at the beginning. Decide in accordance with your oath. Don't speak to anyone whatsoever. And that's, you see, in the 2 references I give there. And then in paragraph 67, we give various other references. Every time he sends the jury out, he reminds them in terms, do not talk to anyone. You have a very serious function to perform. Don't go and mess everything up now, because it'll be fatal to this case if you talk to people. This is the drift, my lords. I have millions more references, which I don't have to hand, but all the time he's saying to the jury, this is a very serious thing. You mustn't speak to anyone. You must remember your oath. And, my lords, I say this is important, and my lords, my lady, I say this is important because after 56 days, the jury would have been well aware of the seriousness of their task, and that they must not talk to anyone, and they must decide in accordance with the evidence.
But that's talking to somebody outside their number. What we're concerned with here is somebody within the...
I will come to what you might call the naughty juror in a moment. But I mean, obviously, it might be said he doesn't seem to have taken very much notice of it. I agree. I will deal with that. There is that point. But well, I'm talking for the moment about I'm going to address the points of law, obviously. But as a matter of fact, the jury had well impressed, and certainly the 10, if I can put it that way, the 10 had well impressed in their minds the importance of deciding in accordance with the evidence. Of that, there can be no doubt. And throughout the trial, they are obviously very well aware of the enormous publicity this case is creating. They know they are doing a very serious job. It's not just a 1, 2, 3-day job, small case. This is the big case in Jamaica. It's on the news every night. Crowds outside the courtroom, crowds in the courtroom. They realise, so to speak, they are separate from the public. And that, in my submission, is an important point when bearing in mind whether the judge was entitled to trust the jury. I'll deal with about the miscreant. And in my submission, he was. He's given these directions. And they have, apart, of course, from the miscreant juror, there's no reason to doubt that the 10 have acted properly. My lords, my lady, the next point I want to emphasise, and I'll come to, if I may, the transcript, but the bribe was offered by the miscreant juror on behalf of, or rather in the interest of, all 5 defendants, including Shane Williams. Now, you can see why I emphasise that, because the jury obviously did not convict Shane Williams, or the 10 didn't. He was acquitted. And I'm going to come in a moment to the transcript, if I may. But while I'm on that point, the Shane Williams point, Chow gave evidence of a fight, or the attack, in which the 4 men, apart from Shane Williams, were involved. In other words, Shane Williams was not himself implicated by Chow in the actual killing. What he was implicated in was that it was said Chow gave evidence that Shane Williams, who he called Terence, was one of the men in the video talking about a killing. And that was the basis on which the case went to the jury. So there was evidence, the judge did allow evidence to go to the jury in relation to Shane Williams, but it wasn't what you might call the same evidence Chow gave against the other 4 men. If I can just give you the reference for Shane Williams's involvement, or rather Chow's evidence of Shane Williams' involvement, it's at E4011. And Shane Williams is one of the people identified in the video, which was said to be incriminating. That was the case against him. But I do submit it is important that that is an indication the jury were not just saying to themselves, I see, a bribe has been offered on behalf of all of them, so they must all be guilty. The jury has distinguished between them.
Are you going to take us to the references to the 5, to the bribe being offered on behalf of all 5?
Oh, yes. yes. Because I would like to go to, it's not a very long transcript, I would quite like to go to the transcript to see what actually happened in front of the judge. I'd like, if I may, to go to the facts first, and then I will deal with the issues of law which arise as a result of them. The transcript is at 5.1, begins, the relevant part, I think, is at 5.167. I should say, actually, 5164 is where the Chambers meeting begins, 2:20 p.m. on the last day of the trial, or rather, last day of the summing up. 2:20 p.m., court resumes, and the judge then reports that he's heard that a member of the jury has been offering a $500,000 bribe to do a particular thing. You see that about a third, halfway down. My lords, my ladies, just for information, the exchange rate at that point was in pounds, 180 Jamaican dollars to £1. So we're talking here about, I think, something in the region of £2,700. That's the total number.
I think I'm on the wrong page. Which page are you on?
5164. Forgive me, my lord. I did say 5167, then I went back to 5164.
I'm now back. Thank you.
So that's the size of the bribe, if I can put it that way. I'm not saying that makes it any better, but obviously not. But on the other hand, it's not such a gigantic sum as to lead to the conclusion something that, well, there can only be an incredibly rich person who's offering it. So the judge says, well, I've heard about this bribe, apparently, and he explains how he's come to hear it. And then at 5167, or 5166, you'll see that the DPP has been called in, about a third of the way down the page. Now, she didn't present the case for the prosecution, but I'm told by her, she's in court at the moment, Miss Paola Llewellyn, that when this incident arose, the judge called for her if she was available to come along, as did indeed the deputy DPP. And so she turned up because obviously this was a difficult incident to know what to deal with. So you see there, 5166, she's come along. And then you'll see what she suggests at the foot of the page, 5166. Judge, it's dependent on what your lordship decides. Clearly that's the issue. We'll have to go to another domain. That's between her as the complainant, a particular person, if there's to be credibility in the matter. That's not for you. It's a very serious matter. So she's not encouraging the judge, so to speak, to make any further investigations into this. I submit quite rightly. Judge, if that report is credible, and having heard the thing, one decision will have to be made in respect of that man today. He's going to have to make up his mind now. A DPP says yes. And then the judge says, this is all very painful, but I'm going to have to arrange for Madam Foreman to come into the chambers. You see that about 2/3 of the way down the page. And then Madam Foreman...
Do we assume that during that period of time, who else has been? Is there any indication who else is with Judge and the DPP?
I think all counsel, I should say, as I understand it, all counsel are present, but not the appellants themselves. I don't think there's any issue on that.
Right. Thank you. Doesn't actually tell us, does it?
You're right, my lord, but I have a feeling, I don't think it's in contention.
Thank you.
And before he says that he's going to call Madam Foreman, he says that he's going to summon that juror, and he's had instructions to the police.
Yes. In fact, he never does.
Yes.
But he does get the Madam Foreman along. And so she turns up. I'm now at 5167 at 2:43 p.m. Judge, you can see what the judge says, 5167, line 19. And if you can, maybe simpler, my lords, my lady, if you read on to 5173, rather than me picking up bits here and there, because there may be other things which I miss out, which you might want to read.
To which page?
5173.
Thank you.
And then I'll make some comments on it.